this is a new webinar software platform for me. So I'm still working the bugs out, and that's part of what you guys get for being in sort of the test group here. So I appreciate you bearing with me. And okay, so it's 11 o'clock, so we'll go ahead and get started. So welcome everybody to our webinar, and very happy that you're here. We are on session 3 of our webinar, and we're going to cover bankruptcies and inquiries. And let me just remind you, make sure I get the screen to work here. So what we have covered the last 2 sessions, and session 1 was really, how do you pull your credit reports? That seems so basic, but I can't tell you how many times people don't do that correctly, and it affects their ability to, number 1, get things fixed, and number 2, if the credit bureaus don't do the right thing, it hinders our ability to sue. And then the second session was really about your biographical information, which so many people skip over that. And honestly, I did for a long time. But I recognize now the importance of it, of looking at your name, your address, your date of birth, social, place of employment, phone numbers, and disputing all the things that are wrong. And we'll talk in a moment about sort of how all this fits a grand strategy of what we're trying to do. But let me do this now. Let me put up the replay for module 1. So if you did not see that, assuming this works right, you should be able to click on this and it'll open up a new tab. Just leave it there and then you can go back and watch it, or you can save it. And let me do the second module also. Share that with you. And I'm not sure if that took the first one away. If it did, I apologize. If you, for some reason, don't have the first module, just email me and I will get that right to you. And let me put my email in for you. This will be just the easiest one to send to me. And let me also get you the tools that we shared in those first couple of episodes. So this is a resource page that should be popping up on the screen for you. And this is, one of these is a Word document, one's PDF. They're the same thing, but this will just help you to sort of go through that first session particularly. And then on the second session, the main thing I want you to see is what we call the biographical tool. It's just an easy way to document what the credit bureaus are saying about you, all the different credit bureaus, and what is right, what's wrong. If you remember, we have 3 buckets. We have, it's correct now. Second bucket is, it's not correct, but it used to be correct. And third bucket is, it was never correct. So, you know, my name is John G. Watts. Okay, so that's correct now. If I had changed my name and it had an old listing, or think of an old address, that would go on that second bucket. It used to be correct, but now it's wrong. And then the third bucket is, it's just never correct. And look, I'm doing this myself because one of the credit bureaus lists my office address as my home address. It's never been my home address, okay? Or it will list my name as Watts John. Well, my first name is not Watts, my last name is not John, so I'm disputing that. So that'll just help you with that. And then there's a dispute letter that we shared last week, but we'll actually give an updated version at the end of this today, because that will have about how do we challenge a bankruptcy or other public record. And then number 2, what do we put about inquiries that are incorrect? And so let me go back to the chat, just make sure I've got everything here. So let me give you a sort of share something that I've been hinting at, but I want to make this very clear. Why are we doing it this way? In other words, the sort of more natural thing would be for me to say, all right, let's like start off and let's find the Capital One and the Midland Funding and the Bank of America and find the errors and dispute that. The reason is we're building something here. So, and I'll remind you of this at the end of this, But we have our credit reports now, assuming you've done the first session, or you can go do it after this. And then we've gone through very detailed the biographical information. And if you're like the typical person that I see in my office, and by the way, what we're doing here is exactly what we do with every single client, okay? So there's nothing being hidden from you. This is exactly what we do. We'll have half a dozen, maybe more biographical errors. So you misspell my name twice. You've got phone numbers that are landlines from 10 years ago. You've got, my place of employment is where I worked when I was 18, okay? And just all these things. So we might end up with a dozen or more errors. And we're telling the credit bureaus about that. Well, think about it, they don't fix that. Let's say they don't fix half of those and it was a dozen errors. Well, now we've got 6 errors. And we're going through today, if you happen to have a bankruptcy on your credit report, maybe there's a couple of errors on that. They don't fix all those. Well, now we're stacking up the errors. And then the inquiries. And look, there's never a time I can remember where I did not have an ongoing lawsuit that's based really solely on an illegal credit pull, okay, what we call an impermissible pull. And so maybe you've got a few of those. So before we ever get to the Capital One, the Discover card, the Midland funding, portfolio recovery, we've got 24 errors maybe. And then we add the accounts. Let's say there's 6 accounts that have errors and they each have 3 or 4 errors. We add all those. So at the end of this, when the credit bureaus come back and they only fix half of this, instead of us suing over one thing, which is legitimate to do, but that gives them the argument, it's not a great argument, but it gives them the argument, it's just a mistake. We just made a simple error. Well, now we go into court and we say, oh, well, they made a dozen errors, 24 simple mistakes. It's kind of hard to sell that to a judge. And so we want our credit reports to be correct. And if they fix everything, wonderful. God bless them. That's fabulous. But when they don't fix everything, we want to be able to stack all these violations up so that the judge is reading this going, good grief, guys, how many mistakes can you make? So that's the reason we're going through this in kind of a methodical way. So I hope that that's helpful to you. Yeah, Joan says a missing sample letter from session 2. We'll get that today. You'll get sort of the enhanced dispute letter. So let me go on to our next slide here. And let's talk about public records. So 3 basic types of public records. There's bankruptcies, there are judgments, and tax liens. Those can be state or federal. As a practical matter, the major credit bureaus, Equifax, Experian, TransUnion, do not report. I'm not going to say they never do, but as a practical matter, for 99.9% of people, they are not reporting tax liens or judgments. They all report bankruptcies though. And so we're going to look at particularly bankruptcies, but understand it's the same concept, the same theory, whether we're dealing with judgments or tax liens or bankruptcies. And I have sued on all of those. We have had lawsuits solely based on false information on judgments, okay? It's the same theory we use with bankruptcies, with tax liens. And if there's some new category that they open up tomorrow, some new public record, you would treat it the same. And it's exactly what I have here on the screen. We find the errors. We tell the credit bureaus about the errors. We make it very, very clear to the credit bureaus. These are the exact errors. We tell them to fix it or delete it. And if they do one of those, that's great. But if they don't, then the third option is we sue them for that. So this is the basic approach. And truthfully, this is the approach with anything on the credit report. You'll notice this is the pattern. When we looked at the biographical information, let's identify the errors. Let's dispute them. And I gave you a dispute letter to do that. Let's tell them very clearly, plainly the errors. This is not where we're playing games with them in sort of the typical credit repair where the letter says, there are errors on my personal information. Well, what does that mean? I mean, you got to tell them. Or there are errors on public records. That's worthless. There are errors on my accounts. Please verify. That's worthless. Okay. It may or may not get a few things off, but we're not suing on that. So this is the basic pattern that we're following. So let's look at it with bankruptcies. And before I do that, I want to give you this little bit of warning, because this is a very common thing where people go, oh, I got the greatest strategy for bankruptcies. So you freeze your LexisNexis report, and then you dispute through the credit bureaus, and they come back and they say they verified it with the bankruptcy court. So you write a letter to the bankruptcy court writes you back, says, we don't verify anything. You send that to the bureaus, and they have to remove it because you froze LexisNexis. That's who they usually get the information from. And now we have proof the bankruptcy court doesn't give it. And so now they have no choice but to remove it. Look, does that occasionally get bankruptcies off? Yeah, occasionally. You could send it on pink paper and, blue font, and that may get something off as well. But, people come to me and say, I want to sue over that. I can't sue over that because it ignores the fundamental issue, which is there an error with the reporting? And people don't understand what LexisNexis is. It's a credit bureau and it's a vendor. And I want to share something with you. This is a video that we did a while back. Let me see if I can pull this up. Let's see here. Yeah, so this is something, again, you may just want to click on this or save it in another tab. This specifically is about a judgment, but involves LexisNexis, and it came out, I think, 2 weeks ago. And I want you to see this because it's very instructive how the courts view things and why you have to find errors. All this stuff about LexisNexis and the credit bureau says I verified it with the court, and really they went to LexisNexis. Judges don't care about that. What they care about, is it accurate? Is it incomplete? Are there errors? That's what they care about. And so again, just sort of open that in another tab, and then you can go back and look at that. All right, so let's now look at how we evaluate the bankruptcy entry. We're not talking about the accounts. We'll cover those next week. But how do we cover the actual bankruptcy entry? And again, if you haven't filed bankruptcy, this will still be helpful because we're learning the pattern here. And I can't remember if I mentioned this last week or not. What I do not want to do is just say, okay, here's a program or here's something that you can just plug stuff into and boom, it'll do the disputes for you. And you have no idea what you're doing. I want you to understand the theory behind this, because then it will make sense. And if you see something a little different, you'll know how to react, okay? Instead of just sort of trusting somebody to send out disputes for you or following some program. I want you to understand the theory, and then you may get somebody to help you if you want. I still think you're better off doing it on your own. Or you may even use a program. And I have some stuff I use internally. I haven't figured out if I'm going to share that or not. But the point is, you have to understand the basis, the theory, the strategy for this to make sense, okay? So I'll share this particular tool with you, but I want you to just look on the screen at what we have. So when we're looking at bankruptcy, the actual entry, we want to pick up every little piece of data, okay? And we sort of pick that up and we put it in the tool. This happens to be a spreadsheet. Could be a Word document. Doesn't matter. It just happens to be a spreadsheet. Put that in there. And then we look at that piece of information. So we put the credit report aside. And we say, all right, I've got, for example, very simple. My credit report says it's a Chapter 7. So I put that on the spreadsheet. And then I look at the actual court file. Now, I probably have that if I file bankruptcy. And I say, was it a Chapter 7 or was it a Chapter 13? If it's Chapter 7, I put that on there. Hey, that's a match. So no errors here. But it could be a 13. And say, wait a minute, there's an error. So I've already identified one error. Go to the next piece of information. The court, the case number, the date filed, the date dismissed, the date discharged, whatever is on there. And we compare that with the actual court file. Again, if this was a judgment, we would do the exact same thing. Give you an example. I had a case where there was a judgment and it was a default judgment. And so it was being reported on my credit reports, my client's credit reports. And we got that judgment set aside. It was vacated. It no longer existed. And we go to the credit bureaus and say, hey, here's the order setting aside the default judgment. Get that off of my credit report. And they did. So we sued them. Paid a bunch of money in that case because it was an error. Okay, we're not playing games with, well, you say you went to the court. None of that matters. What matters is finding the errors. So we just take each piece of information. It may be contradictory. It may be incomplete. Maybe they don't have the case number on our bankruptcy. Well, that would be incomplete. It may be the credit bureaus themselves are inconsistent. So Equifax says this is the case number. Experian says this is a different case number, different date of discharge, different date of dismissal. We put all that together. That's what we dispute because we've identified the errors. So let me know if that makes sense. And I'm also going to check the chat. Those of you that were here on the first one will remember that I said, I'm a guy, so I really can't multitask. So I will look here at what we've got. Let's see. So Kate mentioned something about a lot of soft inquiries. We're going to talk about those. And some of those we can dispute, some we can't. And let's see. Lisa has a question about last week. They won't remove an old married name from 25 years ago, legally changed. Yeah, same pattern. We go, here's the error. I'm disputing it. We give them any proof, so that might be your driver's license. If you got a piece of paper from Social Security, maybe the front page of your tax return has your legal name, whatever it is to prove it. And we give them a chance to fix it. They fix it, great. If in this case, that'd be deleted. If they don't, then we look at suing them. But again, we want to find all those errors so we can stack all those errors on top. And that avoids the argument from the credit bureaus where they go, well, it's just a simple little mistake. Now, you can't have 15 simple little mistakes, okay? Let's see. Kate says, like playing chess. Yeah, we're making moves. We're setting things up, and we're trying to think ahead to anticipate their arguments and take those away from them. All right, so makes sense. Jeff, makes sense. Thanks for doing this. You're very welcome, Jeff. Do original creditors need to report credit bureau's accounts disputed? Yeah, we'll cover that, Marie. We'll cover that next week. And it may take a couple of sessions going over these accounts or what are called trade lines, but we'll definitely cover all those. And Anthony says they will not remove old addresses off my credit report. And so again, you want to dispute those. If you have any proof, you can give that to them. Sometimes we don't. It's like they say, I live at my work address. How do I prove I don't? Well, I know where I live. So I put that out, and they better be careful about not removing that. All right, so let's go now to inquiries. And I'm going to show you these tools here in just a couple minutes. Two sort of varieties of inquiries. There's a hard inquiry and a soft inquiry. Soft inquiry does not affect our credit score. A hard inquiry usually does, but not always. And let me explain. If I go to the car dealership and say, hey, I want to buy a new car, will you see what you can get me as far as a rate? And they pull my credit report. That's a hard inquiry. That will lower my score. It may be 2 points or 3 points or 4 points. It depends on the scoring model. But if I then say, you know what, I want to go to the Toyota dealership. I was at the Honda dealership. Now I'm going to the Toyota dealership the next day. And they pull my credit report. That's also a hard pull. But generally, if it's within a period of time, for cars, it's usually 14 days. They recognize they being FICO, which is really the only scoring company that matters. Now, they have a dozen different scoring models, okay? But generally, they say, if you have a bunch of vehicle loan inquiries all at once, those will be reported on your credit report, but we're only going to count that as one, because otherwise you would be discouraged from shopping around. And think about it from FICO. It's not that they're necessarily just wonderful people. They want you to be willing to have your credit report pulled a bunch of times because people are paying FICO to get those credit scores. Okay, so they have a self-interest in it. Same thing with a home mortgage. So generally, a hard inquiry lowers your score a little bit, but not always. Okay. Now, the types of inquiries, there's really three types that we'll look at. So number one, just the natural thing. When you go apply for credit or apply for insurance, you call State Farm, hey, can you see if I qualify for insurance? Or, hey, Regions Bank or Bank of America, whoever, will you give me a loan? That's pretty easy. Okay. The second type is when you're in a business relationship, and I'll use this example here in a couple slides, but I have a Discover card. So I have a business relationship with them. They can pull my credit report every month, every week, every day if they want to. Now, those are going to be soft pulls, okay? That's because I have a business relationship with them. Now, the third type will really be collection pulls, okay? And technically, these can be hard pulls, but almost all the bureaus, at least the last half dozen years I've been looking at this, that's why I noticed a change about 6 years ago. Those will only come up as soft pulls, okay? Now, there is a fourth type, just promotional pulls, and we'll talk about that briefly, but then we're going to kind of put that aside. So let's go to just applying for credit, okay? This is, again, just like the simple thing. Hey, I want a loan, I want a mortgage loan, a car loan. I mean, we know that, right? They're going to pull our credit report. There's a little bit different version, and that is when you are talking to a company about doing business. And sometimes some courts say they don't have to tell you. Let me give you an example. I don't agree with this, but this one judge did this. So somebody goes to a dentist, not for like, a cleaning, but like they're going to have $5,000 worth of work. And the dentist says, do you want me to go forward with this? Yes. Dentist sends his assistant back. She pulls the credit report. We want to see if you can afford this before we put in $5,000 worth of work. I personally think that's wrong, but I remember one court said that's allowable because you're trying to initiate a business transaction. And so the theory, without getting into all the case law and all the details of the statute, the theory is if you initiate something, well, then that's okay, at least sometimes, for them to pull your credit report. The better practice is for them to tell you. But they don't have the right, except for promotional inquiries, which we'll talk about briefly. They don't have the right to just pull your credit report when you didn't initiate the transaction. So we sued a major bank a few years back because they pulled our credit report without asking. Now they go, oh, well, we knew we could get you a better rate, and we were trying to help you out, and we were talking to this person who sort of connected with you, and we thought that it'd be okay for us to pull your credit report. Well, it wasn't, okay? You have to have my permission, or I have to initiate the transaction, okay? And, again, insurance comes up as well. Typically, though, those come up as soft inquiries, but not always. So let's look at this ongoing relationship. So I mentioned I have a Discover card. They can pull my credit report every month. Typically, it's called an account review. But here's what I want you to think about. What if I closed out my Discover card? And just to make it easy, totally paid off. Can they pull my credit every month? Well, why are they doing that? Well, they're doing that to see, what's going on, and maybe they want to make me other offers. But do they have permission to do that? And I should have said this. There is a mistaken belief, and the credit bureaus lie about this, okay? That's part of where this belief comes from. And I just looked, for example, at Experian, and they flat out say this. They say, you may not dispute soft inquiries. That's absolutely false, 100% false. The Fair Credit Reporting Act, which is what we're looking at, doesn't care about a hard inquiry, a soft inquiry. All the Fair Credit Reporting Act says is if you pull somebody's credit report, you better have a permissible purpose. Whether it lowers their score or doesn't lower it, the FCRA doesn't concern itself with scores directly, okay? So if there's an account review, let's say I pay off my Discover card, I close out the account, and Discover keeps doing account reviews, they better have a really good reason for doing that. Have I initiated some transaction? No. Do we have an ongoing business relationship? No. They got a problem doing that. What if, going back to bankruptcy, I discharge my Discover account? I have no other services or products with Discover card. Everything's been discharged. They're pulling my report every month. It's a big problem for them, okay? So this is why I say you got to look not only at the hard inquiries, which is where we naturally go to, but also the soft inquiries, because they may not have a reason to do it. And again, despite what the credit bureaus will say, you can dispute those. And TransUnion has a nasty habit of, here's what they do. They say, We received your dispute about the inquiry, but the inquiry is a factual matter, therefore we cannot dispute it. I have no idea what that means. Okay, it's like saying, because I'm wearing red socks today, I can't process your dispute. It's ridiculous. It's nonsensical. Okay, we can dispute something on our credit report, any item of information on our credit report that is inaccurate, incomplete, improper. We can dispute that. Okay, if somebody pulled my credit report without permission, I certainly can dispute it. Now, I can also go sue that company that did it, but the credit bureaus do not get off the hook. And whether they go, well, hard inquiry, soft inquiry, I don't care. An inquiry is an inquiry is an inquiry, okay? It's sort of like this. If I go to your house while you're gone and I pick the lock on your door and I go in, I sit down at your computer. Oh, let me see what files, let me see what websites you're looking at. I look around, oh, there's a filing cabinet. I open that up. I go through all. Now, I don't steal anything. I don't copy anything. I'm just like going through your personal stuff. Oh, let me go through your, chest of drawers in your bedroom. Let me go through your closet. Let me look at your picture. See, I don't take anything, but haven't I invaded your privacy by doing that? Is it a defense to tell the cops, well, I didn't steal anything. I just wanted to like snoop around. Same thing with our credit report. We have an absolute right to privacy unless the company has what's called under the law a permissible purpose. So they better have that permissible purpose, whether it's a soft pull, hard pull. I mean, we have hammered companies on soft pulls before. There is no immunity for a soft pull, okay? All there is a credit pull, okay? So I realize maybe sort of beating that to death, but I really want you to understand that because when we talk to lawyers about this, lawyers don't understand this. So I want you to have a clear understanding why it's so important that you look at the inquiries. And let me see here. Just check some of these comments here. Linda says student loans, maybe legit, maybe not. Sit tight and wait on buying. Maybe so. The printing presses are cranked up, so we'll see. Again, we have some questions here about actual accounts, and we'll cover those next week. Sharon says, do we put everything in the same letter or send the personal information now and others later? I like to just do it all at once, okay? And have a big letter, and it's got everything in there. And a couple of reasons for that. One, it's just easier, okay? You don't have to keep up with multiple letters and multiple certified mails and all that. You just have one letter. It goes to all the bureaus. It says, dear Equifax, Experian, TransUnion, SageStream, Innovis, whoever you are sending it to. And it's just, here's everything that's wrong. And if the credit bureaus decide, because they're lazy, because they don't care about you, because you're not their customer, okay, and they don't care anything about you, if they decide, hey, you sent me a 5-page letter, we're only going to look at the first 2 pages because we're sending this off to Bangladesh, to Colombia, to Pakistan, and we're only paying people literally a quarter. We're paying the company 25 cents, maybe 50 cents to have them process your dispute. And they don't have time to go through 5 pages. You know what? That's on them. Now, if our disputes are not legitimate, we can't sue them just because they don't investigate. But when we have legitimate disputes and they choose not to investigate, that's on them. I just sued, can't remember if I mentioned this last week because I may have done this actually, maybe I did this on Monday. But I filed another lawsuit, and Equifax, all 3 bureaus got the dispute. Equifax investigated it and botched the investigation. TransUnion got the dispute and responded, but we had disputed like a dozen items. And there were a couple, they just didn't investigate. Guess what? They get sued because they had an opportunity to investigate. They didn't do a proper investigation. Experian got the dispute and chose not to do anything. Guess what? Those were legitimate disputes. They get sued. So this is kind of the point. I don't really care if they go through this or not. As long as I can prove I did legitimate disputes, I can prove the bureau got it. That's why I harped in that first session on you got to do things by certified mail. If you do it online, you have to have a screen record, okay, Zoom, Loom, snag it, all different things. You got to prove that the Bureau's got it and exactly what you said. And if I've done those things, I've identified the errors, I've done legitimate disputes, I can prove they received it. And then if they choose not to investigate, they choose not to fix it, hey, that's on them. I don't care. So I put it all in one letter. The other reason is if you do multiple letters, they'll go, Judge, we were so confused. We can't possibly understand multiple letters, because it's not like we keep data on every, adult in America, but we're too incompetent to be able to read multiple letters. Don't even give them that excuse. My view is you just send it to them all at once. So Kate talks about promotional pulls and text messages. So the text messages will be under the TCPA, Telephone Consumer Protection Act. And, stay tuned. We'll have a whole webinar training on the TCPA as well. And we'll talk about promotional pulls in just a moment. Let's see. Yeah, so I think we'll keep going here. And let me back this thing up. So debt collectors. So the statute itself says that somebody who's looking at your account for collection purposes has permission to pull. They don't even necessarily have to get your account. They can be reviewing a portfolio of items. It might be not so much credit cards and things like that, but maybe somebody's thinking about, this is called note purchasing, buying a second note on your mortgage, on your house. Well, they might pull your credit report. See, hey, does it look like, you have enough money to pay this? Or does it look like you're about to file bankruptcy? So they may not go through with the purchase, but most courts say they have the right to do that. Now, they have to identify the correct reason. We've seen these note purchasers, they'll list it as like a mortgage application. It's not. It's a collection pull. And so they've got to note it correctly. But it's sort of similar to that Discover card where I said, well, what if I pay it off, or what if I discharge it in bankruptcy? Think about this. What if you pay off the collection account and then Midland pulls it again, Portfolio pulls it again, IC Systems pulls it again? Okay. Do they have the right to do that? Well, they're not collecting if it's paid off. So they got a problem. Or what if it's discharged in bankruptcy? So one thing I do in Alabama, and I know we have some folks on here from other states who do this as well, we defend clients who are sued by debt collectors. Well, what if we win that lawsuit? And then that debt collector pulls our credit report again. Well, that's a problem for them. Now, I do have a little bit of warning on here. You have to make sure, if, let's say, you pay off Midland funding and then 6 months later they pull your credit report, it could be they're looking at another account, a second account, okay? So we have to sort of figure that out, and I'll give you a letter you can send to people that says basically, why'd you pull my credit reports, okay? But this is for debt collectors. So promotional pulls, this is where people, if you haven't opted out, people can go in and do a soft pull, a promotional pull on your credit report. Doesn't affect your score. And then they can decide, do they want to send you a sort of a hard or a solid, the legal phrase is a firm offer of credit. Okay. It just means not like, hey, I pulled your credit report. Do you want to apply? But it's, hey, I pulled your credit report, and what I see right now, you qualify. And you might get this from like Best Egg. I think that's what it's called, Best Egg. I guess that's a play on like Nest Egg, but they'll say, hey, you qualify for up to $50,000 at, maybe 5% interest, and, pay off your credit cards. Well, they'll do a soft pull on you. Now, they may wait until you respond to their letter to do that soft pull. Okay. But promotional pulls are, those are allowable as long as the company follows the law. So I want to share two resources with you here. Let me get these to pop up. So this is FTC website, and and I have the link on the screen here. Well, let me get my mouse on the right screen here. Hopefully that's showing up. But this is the FTC, and it'll explain to you, how do you opt out? There's a phone number, there's a website, and what does that mean? And they say, it's not going to get you out of all sort of junk mail, but, a good chunk of it. And then I'll give you another minute to click on that because I'm not sure when I share these things. So actually, if you guys will tell me, I'm going to share something else. And I don't know if it makes kind of the first thing go away, this FTC. So let me pull this up. Okay, so I'm going to share this now. So this is a video about a company that did promotional pulls and then did these firm offers of credit, but they really weren't firm and they got hammered on this. And so just let me know, can you still see the FTC thing that I put up there? If you have a chance, put that in the chat. And okay, so evidently I can only share one thing at a time. If you missed anything that I've shared, just email me and I'll get that to you. Let me look here at our inquiries. So, all right, somebody asked about how much investigation must they do, and we'll talk about that more in the next couple of sessions. Kate says she needs to move to Alabama. It's Alabama the beautiful, but you don't need to move. This will teach you everything you need to know. And then if you are in a lawsuit or potential lawsuit, I can either help you with that in your state, or sometimes we file these in Alabama, even for people out of state, or I can help you find a lawyer in your state. So, but you'll have so much more success if, whether you're bringing it to me or to a lawyer in your state, you say, here's the package. Here are my credit reports. Here's the disputes that I did. Here's the proof they were received. Here's the results of investigation. And now I pulled my credit reports again. It gives a total package for the lawyer, and you'll just get so much better response doing it that way. Let's see. John Andrew says, what if the collection is past statute of limitation, debt collector pulls your credit report? Actually, debt collectors can collect after the statute of limitation. That's be very, very careful. They don't imply that they're going to sue you, but they would still have the right to pull your credit report. Let's see. Saw a YouTube video of an old case. Consumers sent dispute letters to the credit bureau, later found out in discovery the forwarded dispute was misquoted, totally wrong. Is that normal? It happens some, not as much as it used to, because most of the credit bureaus will now take your dispute letter and they'll scan that in and send that on to the furnisher instead of just reducing it to a 2-digit code. Okay, so we don't see that as often anymore. Let's see. Thoughts on a consumer statement. I don't really see the value of that. That's like, you put a couple 100-word statement. We had a case where they said our guy died and he disputed with one of the bureaus, and the bureaus responded to his dispute, wrote him back and said, no, we verified you're dead, but if you'd like to write a, whatever it is, 200-word statement, we'll be glad to add that. So when I sued them, I put in the lawsuit that amazingly, this credit bureau had the power to reach beyond the grave. And first of all, they're communicating with my guy who's dead, okay? And they told my guy, you can tell us from beyond the grave your statement and we'll add your statement. I thought it was pretty funny. The lawyers for the credit bureau had no sense of humor about it, but the judge thought it was funny. I thought it was funny, and they just don't have much of a sense of humor. So let's see here. Okay, yeah, let's put in the link there. That's great. And all right, does permissible purpose stay indefinitely for a time-barred debt? If they're trying to collect it, they can, but again, we'll have a whole training series on the FDCPA and sort of stopping these greedy collectors, okay? The FDCPA is a very powerful law. So there's sort of other ways to stop them than the FCRA. Let's see, Lisa, if anybody has the links for the other 2 videos, let me see. Lisa, I tried to, let's see, I think this is the second video. The terrible thing about videos is it always freezes you in this really weird moment. So this should be the second replay. And this will be the first replay. Hopefully that will help. And okay, so let's move on from the promotional. I have on the screen let me go ahead and close out something here. So we're not covering employment related. That is a whole different animal. If you're interested in that, it may be like a 2-part webinar on employment, very, very specific. I mean, it almost has nothing to do with sort of credit type pulls, even though they are pulling your credit report, but there's special things they have to say, special things they can't say. Sometimes it has to be on a single sheet of paper. I mean, it's very, very detailed. And this is more for you're going, maybe you've been provisionally hired, but they say this is subject to a background check. And so it's a whole different world. Just if there's interest, email me on that, and I will definitely add that to the list. All right, so here's the tools to evaluate these credit pulls. We want to identify who pulled us. Is it Bank of America? Is it Midland Funding? Is it Portfolio? Who is it? Was it a hard or soft pull? And then were we doing business at the time of the pull? Okay. And think about, was it paid off? Was it discharged? Have we applied to do business at the time? Have we applied for credit? Was this a collection account? And so this is again, a tool. There's nothing magical about it, and you're welcome to change it, make it your own. And I think I shared this before. So in college, I was an accounting major. Flipped at the very last semester to business administration so I could start law school on time. But, I'm not really a spreadsheet guy, okay? But I understand the power of them. I'm not particularly skilled at creating spreadsheets. So any improvements you guys have, send them back to me. And then, when this is sort of put in final format, we'll make it, better. But I'll share those in just a moment. Yeah, Eric says GAAP makes the world go around, right? The generally accepted accounting principles. Let's see. Don says, okay, if I take a necessary screenshot. Yeah, you're welcome to. And again, you'll have the replay link. And so you're welcome to watch this again. And let's see. David asks, if you do a cease and desist letter, are they still allowed to pull your credit report? Yeah, they are. So cease and desist just really means they can't communicate with you except in very, very narrow circumstances. And that's only in writing. But they can sue you. They can credit report on you. They can pull your credit report. It just literally, a cease and desist, the more accurate term, and I use cease and desist also, but the more accurate term is cease communications with consumer. Okay, so it doesn't apply to anybody else. Kate asks, can an attorney pull credit besides the original creditor before filing a lawsuit a year prior? So the attorney, if they're considered a debt collector, or doing collection purposes, they technically have the right. Again, they have to be very careful about that. And I mean, this is probably 2007. A bunch of collection lawyers had me come speak to them about credit reports. And so the title of the presentation was a useful tool or a deadly weapon. And, fortunately I didn't have to fly because I brought this giant knife with me. And I said, is this a tool or is this a weapon? Well, it's both, right? If you're doing steak or something, but you can also stab somebody or yourself with it. And I just warned them about how dangerous it is for lawyers to be credit reporting, to be pulling credit reports. And we very rarely see that anymore. I mean, some people do it, but we don't see it very often. Let's see. Paul says, who's responsible for an illegitimate pull, the puller or the CRA? It can be both. Definitely the one pulling the report. Now, they have to certify to the Bureau, we have a permissible purpose, and generally they have to say what that is. Now, if the credit bureau has gotten a lot of complaints about, XYZ company and they still let them pull, that may be on the Bureau. But when we dispute with the credit bureau and say, hey, this company had no right to pull. Look, my account was discharged. I have no other accounts with them. They pulled my report, 3 months after 6 months after the discharge, well, now there may be liability on that credit bureau for not properly investigating. And when they just sort of give you the Heisman and say, we're not going to investigate inquiries, that's on them. That's very foolish for them to do. Let's see here. Let me go now to a couple of these tools, and let me share these here. All right, so the first thing will be the spreadsheet. And I tell you what, we'll look at this spreadsheet, and so that should be popping up. And I'm going to download that also. And I don't know why this thing comes up in, if you see, hopefully you can see this up here. It's just a weird, like I actually label these things, exactly what they show up here, but the way the software does this. But anyway, so if you look down here at the bottom, and, I'm embarrassed to say this, but I'll say it, for like, I don't know, probably like 4 years ago was the first time I realized on an Excel spreadsheet, you have like different tabs down here. I'm not a spreadsheet guy. I didn't know, because they're like, click on this. And I'm like, it's not on the spreadsheet. And they're like, hey, moron, look at the bottom. There's tabs down there. Like, oh, okay. So look, here's a bankruptcy part, this first section. Yeah, let me just zoom in a little bit. And so all I have is just, credit reports right here. And I've just listed these. You probably want to put the date beside them, or you could, just you right click and insert, and you could put, date of credit report. So obviously make this your own, make it work for you. And then what I have is the red column is just what does the credit report say? And the blue column is, well, what's the actual truth? So you might say, well, Equifax says it's a Chapter 7. It was actually a 13. Okay. Credit report, Experian says it was case number 1, 2, 3, 4, 5, but the actual case number was 98765. You see the pattern here? We're picking up a piece of information from the credit report, putting that on the spreadsheet, and then saying, but what's the truth? Okay. Now, let's say that this is, TransUnion is the Western District of Tennessee. Okay. And it actually is the Western District of Tennessee. We go, okay, that's a match. So no problem there. But like right here, you might highlight this, I kind of like green. Well, that was not the one I wanted. Green, and then make the text in black so it'll stand out. Okay. And I like it in green because that tells me, hey, this is an error and I can dispute this. And if they don't fix it, they may be paying me some money. Okay. So however you want to do it, but you just go through here, we've got the date filed, we've got the date discharged. Well, what's the actual date discharged? Maybe you didn't make it. So if you file a Chapter 13, that's sometimes called debtor's court. Usually you're paying 3 to 5. Now with COVID, it actually can be extended, but 3 to 5 years. And most people don't make it out of that. Their case is dismissed. Okay. So if it's dismissed, it's not discharged. Discharge means in a Chapter 7, your debts go away, at least most of them. But if you got a dismissal, well, then you would use this. Okay. And sometimes they label it wrong. Maybe you got a discharge, but your credit report shows a dismissal. That's not correct. That's an error. Okay. And then just anything else. There might be a particular credit bureau that has another field in there. Sometimes they'll have dollar amounts in there. But the point of this, again, there's nothing magical about this spreadsheet. It's just an easy way to sort of grab from the PDFs of the credit reports. That's module 1 we talk about. You literally copy and paste, copy and paste. And then you have it where you can look at the spreadsheet and go, oh, okay, now I can see the errors. And then it's a piece of cake to then drop that into the dispute letter. I'll show you that in a moment. So let me see if there are any questions about that. Specifically this part of the spreadsheet. Hopefully that made sense. Let's see, Lisa said, what reasons would a collector not report to credit bureaus but file suit? The reason, Lisa, it's a great question. when these guys credit report, they only do it to gain incredible leverage over you, okay? Because, I mean, a $50 collection account can be just as devastating to your credit score as a $50,000 collection account. But the reason some of these guys don't do it is because they don't like getting sued. I mean, I'll just tell you this. I'm not going to give you the details, but we've sued collectors for false credit reporting, and it might be $500, okay? And we've had six-figure settlements on those. So credit reporting is very, very dangerous. You know, we used to kind of insist that companies delete credit reporting when we would settle with them. And I've gotten to the point now where I say, they go, well, John, you know, my client's really going to fight you if you want this deleted. I go, no, leave it. They're like, really? I thought you were real worried about credit reports. I'm like, I am, but I have so much confidence that your client will mess this up and we get to sue them a second time. And, you know, they always get very offended. These, we call them tall tower lawyers. They're, you know, the real tall buildings, and, you know, all their names are the third and the fourth and the fifth. And, you know, well, my great grandfather did the, you know, I don't care. Okay. And then when we sue a second time, we go, we told you. And they're like, I know, you know. And so that's the reason, Lisa, a lot of times they don't credit report, because they're afraid of it. And they know it's so dangerous for them. And they're like, hey, if we're going to sue you, then we're not worried about credit reporting. So give me just one moment. And typically you'll see this on debt buyers, like at least in Alabama, Unifund. They file suits. They do not credit report. Cash, CACH. I don't see them credit reporting recently, but companies that have sort of a longer lead up time to suing you, like Midland Portfolio, Jefferson Capital, these debt buyers, they credit report because, again, it's great leverage over you. Let's see. Yeah, another lawsuit later. That's right. So William says, is it inaccurate if the case number is not exactly like it shows on the court docket, missing dashes and letters? So say it's supposed to be 23-4567-ACT. The Bureau shows 234567 or 234567 ACT. So I wouldn't worry about the dashes and things like that. And typically the letters don't matter, although you do have to look at it. I mean, nothing wrong with disputing if they're missing the letters. But, and look, sometimes these things will be redacted. There'll be like a little asterisk mark, you know, and that's fine. But when they get it wrong, okay, that's when I would dispute it. So we're not worried about, and it's a great question, but we're not worried about dashes and things like that, you know, or they might type it CH13 for chapter 13, and then the other one might spell it out. That's fine, okay? But it's when they get the wrong chapter, or they say you filed this in the Northern District of Alabama, and really I filed it in the Middle District. Or they say the date filed was March 1st, 2020, and is really April 2nd, 2020. Well, that's not the same thing. That's wrong. So I would dispute that. Let's see. Richard asked, dismiss bankruptcies the same way as you would on discharge one. Yeah, you know, again, it's going to be a public record. Could be a tax lien, could be a judgment, happens to be a bankruptcy. And if it's dismissed, I'm going to go through and literally, it's like I'm picking up each piece of information, looking at it, going, is that right? If it is, okay, you know, they did the right thing. But if it's wrong, I'm going to dispute that. Let's see. Joe asks, is furniture required to report to credit bureaus on a regular basis? It's an E8 question. So what Joe's talking about here is E8 is under the FDCPA. So section 1692 E8 says a debt collector that knows you dispute an account must mark the account as disputed. So what Joe's asking is that debt collector who's a furnisher, because they furnish, they provide information to the bureaus, that debt collector, do they have to do that every month? Okay, because if you dispute and then they update and don't mark it as disputed, you sue that debt collector. But what if they don't update? Unfortunately, the cases say they don't have to update. And but that gives you a basis to dispute through the bureaus to say, hey, what's called Metro 2, that's the standard that the industry standard they have to follow, requires that everything be reported at least on a monthly basis. So you say, hey, this debt collector is not reporting on a monthly basis, make them report or get off my credit report. And that typically will make them credit report. And if they don't mark it as disputed, then you have that claim. Again, we'll cover the FDCPA in a separate training, but hopefully that helps you there. Let's see. Flora asks, are you sharing the spreadsheet with us? Yes, that should be a handout. Yeah, it looks like about 30 people have clicked on it. So if you have any trouble getting that, just let me know. Just email me and I'll send it to you. So Marie asked, does date change the current date when they report monthly? Or is that re-aging? No, re-aging, and we'll talk about that when we get into the trade lines or the accounts, but re-aging has to do with the date of first delinquency. That's your trigger date for how long can this thing report on your credit reports, okay? And so whether they update it, don't update it, that has no impact on that. Darren says, yes, it's in the handouts tab above the comments. Yeah, so on my screen, I don't know if this is how yours is, but my screen has like chat and then handouts. You have to sort of flip there to get it. Let's see, can you provide account spreadsheet now? So we'll cover that next week, Kate. And the reason I'm doing this, I'm not trying to drive people crazy, but if I had started this out with, here's how we dispute the accounts, here's a spreadsheet, 90% of people would not worry about the biographical or the inquiries. And like I said, when you understand the grand strategy here, which is we want to get as many errors as possible identified and get them fixed, that's great. Get them deleted, that's great. But if they don't, it gives us so much more leverage in a lawsuit, so much more powerful lawsuit. And so that's why I'm doing this kind of step by step, is we're building up to those accounts. Let's see, Lisa, why is TransUnion the only one that reports when the account be deleted? So Experian does fairly often. And Equifax, actually Equifax is the only one that does it the right way. You're supposed to report the date of first delinquency. TransUnion and Experian refuse to do that. They'll give you the estimated date, but when you compare that with Equifax, and it's 7 years, they don't match up. So it gives us an opportunity to dispute and say to Experian and TransUnion, you better give me that date of first delinquency, because what you're showing in Equifax, those don't match. Okay, so again, we'll cover that when we get into the disputes. Yeah, so Leroy asked about debt collectors. Do they have the right to pull your consumer report when you don't have an account with them? They're alleging you owe them a debt definition. So the general answer is yes, they do have the right. There is an older decision that sort of gets into the weeds about what exactly is an account. I can tell you most judges don't care anything about that. What they say is, all right, debt collector, were you looking at getting an account, a receivable, something to collect on? Yes, I was. Then they're good. Okay, so that's not really a path I would particularly go down. Unless it was a hard inquiry, then I might look at it, but almost all these are soft inquiries. And there are better ways to go after the debt collectors, okay? So let's see. Yeah, I understand, Kate, trying to get a head start. We'll get there. Just if you do all the other work, then when we get there, there's a lot of work going through the trade lines and the account. So you really have to have this stuff done first. And Eric says, making it so it's hard for them not to get sued because you're actually understanding what's illegal. That's right. And here's the thing. We don't trick them, right? We're not sending these vague, obscure things. Now, just a little caveat. Sometimes we are a little vague in the dispute because we're not going to sue the bureaus. Like if I've paid off an account and Capital One knows I paid it off, normally I'll go through a very detailed dispute, but I might just say, hey, check with Capital One. They know I don't owe them anything. They know it's reporting wrong. Go talk to them. Well, I can't sue the credit bureaus for that because I didn't give them enough information, but I can sue Capital One if they don't fix it. But that's a very advanced technique. For right now, I would just keep it very sort of, straight ahead. Very clear, very clean, and you'll be in good shape here. Let's see. Okay, so Don's got something with some files that are merged. Don, just reach out to me directly about that. That's what's called a mixed or merged file. So, I'm John Watson, Alabama. There's another John Watson, Alabama, and they've merged our files together. Just get with me directly on that. I'll just put my email in again, and I'll be happy to help you with that. Let's see. Okay, so Darren, so we're talking about full file disclosure. We'll cover that. That's a little bit more advanced. Without getting into the details, you can ask for the full file disclosure. Unfortunately, a lot of courts say what they send you, just your sort of normal credit report, that is your full file disclosure, even though it's not. And so when you do a dispute, you should get the results of investigation back. You can ask them for the full file. They don't have to give it to you then. And judges are not going to really worry about that when we can go to annualcreditreport.com once a week for free, through April of 22. So let me just show you real quick on the inquiry tool. Again, we just have like credit report, date of the report, who pulled you. I think I left out a column for, is it a soft pull or hard pull? I mean, you could just write that in there. But again, we just have, the ones in red are, did you have some type of business relationship or had you applied? The ones in blue, just to kind of make you think through, was that closed? Was it paid off? Was it discharged? Or you could add a column, hey, I beat this company in the debt collection case. Is it a collector? Did you owe it at the time? Anything else? Again, just to get some information on there. Let me share with you the letter. All right. Actually, I want to share something else with you first. This is a very simple letter. And let me download this and I'll pop it up on the screen. So again, very simple letter, just says, hey, I saw that on whatever reports I've just listed, 5 reports. And, if it's only TransUnion, you just delete everything but TransUnion. Then you would just change this to, I saw that on my TransUnion report. You pulled my credit on this date. I don't understand why you did that. I don't think you had the right to do it. Please either get rid of that inquiry. In other words, go back to TransUnion and tell them to delete it, which they have the right to do that. Or you tell me in writing why you had the basis. Now, technically, they don't have to respond to you, but it's very, very dangerous for them not to. Because if you sue them, it turns out they did not have the right to do this. And the judge is looking at this saying, and she gave you an opportunity and you just ignored them. That's bad. Okay. You also could file a CFPB complaint about it and say, hey, I asked them for the proof. They wouldn't give me the proof. They wouldn't give me the basis. The CFPB, look, I don't care if you like Biden or you like Trump. It's a different CFPB now. They're a little more aggressive now. And so companies are more worried about that. And so, again, this is just a very simple little letter that you can do. This next letter is going to be kind of the updated version of what we shared last week to dispute the personal information. So let me pull this up. And so you'll notice this is exactly what we did before. We've got these 3 buckets, right? We've got it's correct now. It used to be correct, but it's wrong. And it was always wrong. So, here's the only correct information. This used to be correct, but now it's wrong. And we explain why we don't want old addresses, old phone numbers. This information was never correct. And I've just highlighted in yellow. Obviously, if you don't have a bankruptcy or everything's correct, don't worry about this. But this is just a little sort of template to follow. Hey, Equifax, you have the following incorrect information. And you just delete what is actually accurate. But you'd say, look, you say it's a chapter 7, but the correct information is chapter 13. You say, like this one right here, here's the date filed, but the correct date filed is, and I've just copied that for Equifax, Experian, TransUnion, SageStream, Innovis. If you pull LexisNexis, just add that. Again, this is just a tool for you to help you organize your thoughts and build that dispute letter. And I think I said this before. Don't worry about how long it is, okay? There are these credit repair, self-proclaimed gurus who really don't know what they're doing. And these guys have never sued, and they'll say, never dispute more than, what is it lately, 5 items per letter and only 2 errors per item. And you do that because you don't want them to think this is credit repair, and you don't want them to reject you as being frivolous. Well, maybe if you're sending out just bogus credit repair letters, that is a legitimate concern. We're not doing that. We're sending out real dispute letters with real errors. And if the credit bureau goes, you know what, I deem this to be frivolous, that's very foolish. Okay, we'll talk about that in a couple of weeks. We probably would resend it to them and give them a second chance. Sometimes to amuse myself, I'll have my clients write in red ink across the copy of the first letter, second and final notice, sort of like debt collectors do. It just amuses me to do that. And if they reject it again, we sue them, because they can't just reject something as being frivolous when it's not frivolous. Okay, that's not a get out of jail free card for them. And so we sue them, and they go, but we didn't actually investigate. I go, yeah. So you automatically violated the law, assuming we have legitimate disputes. Okay, but here's the real reason the credit repair places say only dispute like 3 items or 5 items at a time, because you're paying them monthly and they want to drag this out. If you look at the credit repair software, all the pitches are, this is a great industry, and it can be a very good industry, but they spend more time talking about, think about, you get this stream of recurring revenue, $100 a month, $200 a month. If you get 10 people, if you get 100 people, if you get 1,000 people, the goal is to keep them in there as long as possible. Well, okay, I think that's kind of shady to do. But my goal, if I'm fixing my own credit report errors, your goal, if you're fixing your errors, is to get it done as quickly as possible. It's not to drag it out. So we do a dispute. We put everything in there. If they don't fix it, maybe we dispute again. And we'll talk about the strategic reasons. Or maybe we just sue. And then, trust me, when we sue on legitimate things, they delete it. They pay you money. If you have a lawyer, they pay your lawyer money. Everybody's, they're not happy, but we're all happy, okay? And so there's none of this dragging it out, okay? And so don't worry about how long your letter is. Somebody will say, well, they won't read anything if it's over 7 pages. Okay, then they're not going to fix stuff and they're going to get sued. What do I care about that? So I can't remember if I mentioned this, but I help people with tax resolution. So, you owe the IRS $50,000, $200,000, we'll help you to solve that. And you can imagine it's no excuse for me to go to the IRS and say, well, it was like a 4-page letter. And my client just didn't have the time to read past page 1. So we really didn't know we owed all this money. So you can't penalize it. You think the IRS goes, oh my goodness, you have 4 pages too. No. If the bureaus choose to not read the letters, that's on them, okay? And they can pay the price for it. So then down here I have inquiries, just a simple paragraph. I see that blank pulled my credit report from, and again, you list who it is. I don't believe they had a permissible purpose. And then I have some reasons listed here. I never applied to do business, never did business. The account was closed. The account was discharged. And again, you can just sort of copy and paste that if you have multiple ones. So that is the tool there. Let me go back to the slide presentation and see here on the comments. So Elisa says, in bankruptcy, Experian has a wrong address, an account number, TransUnion doesn't update, Equifax deletes it. So again, with Experian, they have the wrong address. And I may not have even put that in the spreadsheet. You can just list that under the court. But that would be a legitimate basis. If they say the address is, you filed in Montgomery and really you filed in Pittsburgh, well, it's wrong if they have the wrong address. Let's see. Can you sue if the CRA is not allowing you to get weekly report under the CARES Act? So it's not really under the CARES Act that you can get the weekly report for free. That's just the bureaus are doing that. So you really can't sue them for that. But keep in mind, we talked about the first module. You can go to Experian.com, get it once a month. You can go to myequifax.com and get, I think it's $6 a year. Okay. You have Credit Karma. It's not exactly your true information. And so don't use that if you can get the real reports. But if you have trouble, you can always use that as kind of a backup. Let's see, Darren, in this case, I was just asking for the credit report, but they sent a dispute letter back. Yeah, look, the credit bureaus, here's the crazy thing. And there are legitimate credit repair companies out there, okay? There are a lot of crooked ones. But the credit bureaus will say, hey, this is a form letter, so we don't have to read it. And I'm like, all you send are form letters, Equifax. If I ask you all these questions, and by the way, I do in my dispute letters, I ask questions of them. And we'll say in there, don't send me a form letter. Guess what? They send a form letter. Well, you know what? That goes in front of the jury. And then go, what? But we're such a big company and we don't want to spend any money and we don't want a human being involved, that remotely speaks English and is remotely in the United States. And so we can't respond to letters. And, so you ask for the report and we create some dispute, you can't expect us to be accurate. And then they'll go, we are 98% accurate. Okay. Remember, we talked about this before. I don't have any right to choose whether or not they have a credit report on me. And when did 98% become accurate? It all depends on the context. The doctor says 98% of the time, I amputate the correct leg. I mean, only twice out of every 100 do I cut off the wrong leg. That's a problem. Air traffic controller goes home. She tells her husband, great. 98% of the flights that I was working on today didn't crash into each other. I'm fabulous. No, that's no good. Okay. To say that there's a 2% error rate on credit reports is terrible. They need to fix that, particularly when we give them the opportunity to fix it and they just ignore it. That's on them. So let's see. Kate says, data mining on my credit report. Yeah, so this is, again, they can do this promotional stuff. Now you can take that away and that gets rid of almost all of it. Just follow that FTC site. Let's see. Can you please send the handouts for second class as well as today's class? Gerald, if you'll email me and I'll do that. I know some people maybe are watching this, like on a phone, while they're out. So just email me and I'll send them to you. Pandora says, what if the bureaus don't remove all of the biographical information? So we're talking about all the inaccurate information. Well, then we look at suing. Okay. Now, go back to that sort of grand strategy. Let's say they have my landline number from 10 years ago and I tell them to remove it. They don't remove it. Should I sue on that? I don't know. Maybe I wouldn't sue just on that. But what we're doing is we're getting that. And then we're getting, they have my name misspelled that they wouldn't fix. Would I sue just on that? Maybe, maybe not. They have my employer wrong. Would I sue just for that? I don't know. And they have these inquiries that are wrong. And they have information about my bankruptcy that's wrong. Maybe each little piece I wouldn't sue on. And then you add on the accounts or the trade lines. And there's another dozen errors. And you put all that together. Now I can sue. Okay. So that's why maybe in isolation, we don't sue, but you put it all together and it's very, very powerful. So I hope that makes sense. Let's see, Paul says, can we get an accounting from the CRA exactly how the reinvestigation was done? What was the response, actual communication? You would think so from reading the law, But as a practical matter, no. But you can ask them what the procedure is they went through, and they'll give you just generic stuff. Okay. Here's why, in a sense, it doesn't matter. Because either the information is wrong and they don't fix it and we sue them, or it's accurate, and frankly, whether they do a good investigation or not doesn't really matter. Okay. So we've got to have very clear errors, and we'll talk about that particularly next week. So yeah, we're too lazy to read isn't a valid defense. They think it is, and they'll get these fancy lawyers that will, Judge, it's ridiculous to think we would read this long letter. And of course, you send them a short letter, and they go, you didn't give us enough detail if you'd only send us a long letter. So yeah, they will argue whatever helps them at the time. Is there a way to find out, this Kate, if the original creditor sold the account and got it back in order to sue? So not really. It's unusual for a creditor to actually sell an account to a debt buyer and then take it back. Usually that only happens if maybe the account was discharged in bankruptcy and the creditor sold it by mistake. But what you'll see is a creditor will send it out for collection, but the creditor still owns it. They're just sending it to this debt collector, and then it comes back. So that's not going to be reported on the bureaus. The only thing, not to get too far in the weeds, but if the original creditor, so Capital One is on my credit report, and then they send it to a debt collector, but they still own it, Capital One still owns it, that debt collector can report, but Capital One can't have the balance on there. Say it's $1,000. It can't be, oh, Capital One 1,000 and the debt collector 1,000. It looks like, oh, 2,000. That would be wrong. So normally, if the collector is going to report, the creditor will go away if they've just assigned it. If they've sold it, a lot of times the creditor goes away. Some will stay on there, and they'll say in the comments, transferred or sold or purchased by another lender. So hopefully that helps you there. Let's see, offer valuable information. Well, you're very welcome, and I appreciate all you guys on here. I think, yeah, we're going a little bit long, and looks like we still have, a few people on here, so that's good. Lisa says, I like Credit Karma because they send me updates. Yeah, it's fine. It's a good supplement. I would just make sure you get your real reports. You get so much more information on your real reports, including the promotional or the soft pulls, the account reviews. You'll only find those on the real reports. Let's see, Joe says, in regard to bankruptcy, you mentioned technique of freezing LexisNexis, getting a letter from the court, they don't report. Are the bureaus required to get data from the original source? So, Joe, it's a great question. If you read that case that I mentioned, and let me see here. This is, let me get the best link here, and I'll put this in the chat. If you read this, it's about a judgment, but it also involves LexisNexis. And part of the theory was, well, Equifax said we contacted the court. Really, they didn't. They sent LexisNexis to go look at the court file. And the plaintiff was complaining about that. And the court was like, we're not even going to decide if that matters. They certainly suggested they don't think it matters. But they said, particularly, it doesn't matter because the information was accurate. Okay. And here's where the confusion comes in. LexisNexis does have a credit report, okay? But they're also a vendor. So you can freeze LexisNexis, but that doesn't prevent LexisNexis from going to Pacer, which is just an online system for your credit report, to, for the bankruptcies, to pull the bankruptcy record. So you may freeze LexisNexis, but Equifax still has LexisNexis go gather this information. Now, they may say we contacted the court, and this case decision I have up on the screen that I sent you the link to suggests that's not a problem. Again, it all comes down to, is there an error or not? That's really all that matters. Let's see. Darren says, would it help, or should we try to apply for credit, give us better standing for damages? So we'll talk about that in kind of the final session when we're looking at results and all that. here's the deal with fair credit reporting. Imagine a timeline. Here's in 2020 and here's 2021. If I pull my credit in 2020 and I dispute it in 2021, in other words, I go apply for credit 2020, and I start working on my credit report in 2021 and they don't fix it, I can't go back to that credit pool for damages. My damages only flow from the moment, as a practical matter, there's always exceptions, but as a practical matter, it only flows from when they messed up the investigation going forward in time. So we really need to do the disputes, get the results back, and then sometimes we do go apply for credit before we sue because maybe we'll get approved. Sometimes things happen. I've got a client that was probably turned down by 10 mortgage brokers, and then the 11th one approved them. Now, we're still going to sue, but I didn't want to say don't apply because I don't think you're going to get approved, okay? Now, I would not just go apply for the sake of the lawsuit. Make sure there's a legitimate reason. I do need this credit card, or I do want to apply for a consolidation loan, or I do want to see what I can qualify for in a mortgage. Have a legitimate basis, but it certainly does help you with damages. Milton says, what if I was sued by a credit card and won? Can I get that information? Yeah, absolutely. Milton, reach out to me directly by email. Trying to think right now. I don't know. We've got 4 or 5 of these going right now where we got sued, we won, and typically we'll dispute through the credit bureaus and tell them to get it off. And if they don't get it off, we sue the credit bureaus as well. And those are big cases. But sometimes we win, and then we just wait and see, are they going to take it off our credit report? And if they don't, that's an FDCPA violation if we're talking about a debt collector. Now, if it's an original creditor, you have to dispute through the credit bureaus to be able to sue them under the FCRA. But Milton, reach out to me, and if you'll send this to me by email, here's the lawsuit filed against me, here's where I won, and here are my credit reports now. We'll take a look at that. And I'll be glad to, whether I can help you or say, here's a lawyer that can help you in your state, or we can work together. So just get with me on that. But yeah, absolutely. We do that literally every day. We send out those disputes. Okay. Paul says, how do we determine if a collector is an owner or if they were just hired? Usually when you get a letter from the collector, it'll say who is the owner now. And if they have their own name, they're saying they bought it. Or if they say AT&T or Capital One, you can also call them and say, hey, are you guys just collecting, or do you say that you own the debt? And here's a simple rule with the FDCPA, Fair Debt Collection Practices Act. If they lie to you about anything, my simple solution is you sue them, okay? And when we sue them, they go away, it comes off our credit report, they pay us money. So if they lie about that, you sue them. If they say, you can't file bankruptcy anymore, they change the law, you sue them for that. Any lie. Basically, our normal approach is to sue them for any lie. Let's see, Tony says, send a dispute letter to Experian by certified mail. Someone signed for it on April 2nd. They said they never got it. Should I just do another letter or take another approach? So one of my current lawsuits against Experian is exactly this. I know they got it, but they deny it. They got it. They didn't do an investigation, so we sued them. Now you can send them another letter. You could set up an account on Experian.com, upload your letter. I think Experian lets you do that. Just make sure you're doing the screen record, like we talked about in the first session, of the whole dispute process if you're doing it online. So you can do any of those, and there are different reasons and strategies for each of those approaches. So either if you feel confident about your letter, legitimate disputes, and you know they got it and they just didn't do an investigation, you can sue them, or you can give them another chance. So yeah, again, we'll talk about that in a couple of weeks. Let's see. Sean says, how do you dispute the older derogatory events which are not on the recent payment history? So maybe email me directly on that so I know exactly what you're talking about. Different bureaus have things laid out differently, and frankly, it can vary. Did you get a paper copy in the mail? Did you get it online? Did you get it through annual credit report? So anything on there, okay, you can dispute if it's inaccurate. Now, remember this, if on my Discover card 2 years ago, I was late, so June of 2020, I was late, and I'm not late now. If I truly was late in June of 2020, I don't need to be disputing that because that's accurate historical information, okay? But then some things are current information, like pay status is current information. And so there's kind of a classic thing. And a lawyer I know was involved in this case, and he may be on here. This is the Masick case, James. So where you pay off a debt, but they put on their current status as 120 days late, but you paid it off. Well, that's wrong. That's not accurate. Again, we'll cover that when we get into the trade lines. Let's see. Marie said third-party credit reports, Credit Karma, Identity IQ, Smart Credit don't always match up. Yeah, they're fine if you don't have anything else, but you have to get the real reports. Even if you do a dispute based on the credit monitoring, I mean, we won't sue unless we see the actual reports because they're just notorious for having incorrect data. And it's a shame because they're very, very handy, but you got to get the real reports at some point. Yeah, Sean says, my FICO, Identity IQ, different information. Kate says, inquiries will lower your score. So hard inquiries will some of the time. Again, if they're bunched together, you can pull your own report, a dozen times a day. It won't affect anything. Potential judgment buyer have permissible purpose. That's from Jeff. Yeah, I would say so because it's all related to collection. Gerald says, do you practice South Carolina? I don't directly, but there are some lawyers there that I can work with, or I can give you their names and you can talk to them. Just reach out to me on that. Let's see. Wonder how much I'm worth with the lawsuit. It's funny when we do lawsuits, so I live in this world, so I know what the values are, but to somebody else, it's like, well, what's the difference between a $5,000 settlement and a $155,000 settlement? It's obvious in personal injury, and I've done personal injury for 26 years now. Everybody knows if an 18-wheeler runs a red light and breaks both your legs, that's a valuable case, okay? But people are walking around with more valuable cases under the FCRA and they just don't know it, okay? So, we really have to follow that pattern of, here are my credit reports that led to my dispute letters. I can prove the bad guys got them. Here's what they said in response. And then here are my new reports. If we have all that, then we can give a pretty accurate picture of, do you have a case and what that case is worth. Yeah, Marie says third-party reports are good for alerts. That's right. Would you advise disputing through credit bureaus if you're in a lawsuit with them? I do. Now, they freak out and say, you have to send those through the lawyers. You don't. And sometimes they refuse to respond to them. And they go, oh, we're in litigation now. We have a litigation hold. I don't care what you call it. The Fair Credit Reporting Act still applies, and you have to investigate my disputes. And if you don't do it, guess what? That's either another lawsuit or we amend the lawsuit. Let's see. D asks, is GLEL a debt collector? I don't know. I'm not sure about that. A debt collector is going to be somebody that buys a debt that's in default, or they're assigned a debt that's in default, and their principal purpose is collecting either defaulted debts that they bought or collecting debts for others. So I'm just not familiar with them. Joseph says, an email about voluntary repossession in Florida. Have a chance to review it? I'm thinking I must have missed that, Joseph, so I apologize. I have been, it's a good thing, but I've been in court a whole bunch. And so if you don't mind, send that to me again, just because I literally get like 150 emails a day, and my staff and I, we try to make sure we cover everything. But if I missed that, just resend that if you don't mind. What if attorney suing is listed on debt collector website as a team member practicing under separate corporation? Yeah, that's going to get kind of in the weeds there, Lisa. So I would just sort of gather all that information together. If it looks funny to you, do a dispute and lay all that out, and that would be fine. Then see what happens in response. Kate, Kansas attorney. Kate, I know I've been missing you, or more accurately, you've been missing me, and I apologize. I've been just jammed up, but I'll get with you and we'll talk privately. Jason had a letter for collection, belongs to my sister. So that's very interesting, Jason. You got an email that contained a letter that's not your debt, but is for your sister. So first of all, in November 30th this year, the rules will change. And I'll give you a little caveat to that. That will allow debt collectors to like send direct messages on Twitter and Facebook and text messages. Kind of crazy. It's going to be a nightmare. I'll tell you this, as a lawyer, it's going to be unbelievable opportunity because they will absolutely mess this up. And the FDCPA is what's called a strict liability statute. It means we don't really care. Did you have good intentions, bad intentions? Did you violate the law? Boom, you get sued. They're going to just completely mess that up. They can send emails now, but they have to be really, really careful. And the fact that they sent it to you, unless she gave your email as her email, then that's going to be what we call a third-party disclosure. And I'll just tell you this, frankly, I love third-party disclosures. That's where they like call your neighbor and say, hey, John Watts is not paying his debt, or they call your coworker, your boss. I mean, even if they don't disclose the debt, if they like call all your neighbors and say, can you go take a message to John Watts? That's what's known as a block party, okay? Because it's this intimidating thing of I get all these text messages or people knocking on my door, handing me sticky notes. And if they do it to your office, it's called an office party. They call all your coworkers those are fabulous cases. So I would be very interested in seeing that, Jason. Just check with your sister. Did she give your email to the original creditor? And if not, I'd like to just see exactly what they sent you, and I'll give you my thoughts on that. So just email me. Oh, D says Great Lakes education loan. If they were never in default, they certainly would not be a debt collector. And this is probably, I'm not a student loan expert, but you have sort of the what do they call it, the guarantor or whatever. I mean, there's sort of different levels here. I think they would not be a debt collector. Don asked, pay for delete on 2 American Express cards. We'll cover that in a separate webinar, but the short version is you call them, you negotiate before you close the deal. You say, and I need these deleted. And so it's kind of like you're sliding money across the table, but your hand's on it, and now you pull it away. So when that collector at Amex, senses, oh, I've got a settlement, he or she is more reluctant to blow that thing up. Now, if you call them and say, hey, will you do a pay for delete? It's easy for them to say no. Okay. Now, I'll give you a little bit more advanced strategy. You do that, even if they won't do the delete, you still settle it. And guess what? The moment that money hits their account and it's cleared and all that stuff, is your credit report accurate when it says you owe $10,000 to Amex? No, it's not, because you paid them $5,000. Well, should your credit report say you owe $5,000? Nope. How much do you owe? Zero. Nothing. So you settle with the original creditor. You immediately dispute as soon as that money changes hands. In other words, as soon as American Express says, yes, the money's cleared and we're good to go, you dispute it. Now, most of the time they'll fix it, but they don't always fix it. That's a great lawsuit, right? Because they have verified false information on your credit report. Again, it's the same pattern we're talking about. You identify an error. Hey, it says, oh, $10,000. I owe them $0. And then they do the dispute. The results of investigation comes back. You owe $5 or you owe $10 or whatever. You sue them. I mean, I've got a pending lawsuit right now. It involved a collection case, but it's the same principle. They sued us. It was an original creditor. We paid them some money. After we were done, they kept the balance. So like they sued us for $5. I think we paid them $2, and they put $3 on the credit report. That's not true. We dispute it, and they verified it. It's a big problem for them. All right, let's see here. Does third party have a case against a collector, or is the case only the correct? But really, that would be Darren. I think it was your sister. It'd be your sister has the claim. Let's see. Same for collections paid. Yeah, when you pay a collection, you pay an original creditor, you owe them zero. And so a lot of times the debt collectors will leave either the full amount on or kind of the difference. So again, you owe $500, you pay them $300, they'll update your balance with $200. You don't even have to dispute that through the bureaus. You can sue them under the FDCPA. That's that section E8 of the FDCPA. And yeah, Michael says, interesting, recent 11th Circuit opinion about sending collection info to a letter vendor for debt collectors, a third-party issue. So this case came out, I think yesterday, Michael. And it basically says when a debt collector sends your information along with everybody else to like a vendor to print the letters, that may be a third-party disclosure. I doubt that will stand, okay? I think that they'll probably pull back from that, but it is a very interesting case. Let me just do a couple last things here, and then we will wrap this up. So we looked at the tools. Just to remind you, and I've talked about this, we're just stacking all these errors up, okay? That's the goal, to get them fixed or be in a position to sue. That's our goal. So we're not disputing things that are correct. We're only disputing errors. And all those errors are piling up in our letter. And then either they all get fixed or they all get deleted, or there are some that are not fixed, not deleted. And then we look at, do we want to dispute again? And sometimes there's a good reason to dispute again. Other times we say, nope, we're going to go ahead and sue. So listen, guys, if there's anything else, let me know. But otherwise, we will call this a day. And I didn't mean to go quite this long, so thank you for your patience. And Alfred says, be emailing you. And look, you guys are very kind, and I appreciate. Let's see, we'll take one last one here. John says, what do you do when you receive a letter back from a dispute? It says inquiries are factual. Yeah, that's that kind of that garbage that TransUnion particularly does. And here's what they're saying. It is a true statement that, Citibank pulled your credit report. Okay, I get it. But if Citibank had no right to pull, then you, the credit bureau, had no right to give them access. So let me sort of use the technical language. We have the credit bureau, and then Citibank, who pulled my report, that's a user of the credit report. So the user has liability, and the credit bureau has liability for that. So when they just, again, sort of give you the Heisman and say, no, we're not even going to investigate it. If the credit pull was legitimate, then you can't sue. But if it was wrong, now you're suing the credit bureau for not doing a proper investigation, not doing any investigation, and for releasing your information when there was no permissible purpose. And you're suing the user for pulling your report without having permission. So that's how all this kind of comes together. So no matter what it is on the credit report, if it's inaccurate, we can dispute it. And now the credit bureaus have a choice, and they often choose the wrong choice. So, all right, guys. Well, listen, y'all have a wonderful rest of the week, and I will catch you next Thursday. All right. Bye-bye.